I was in Washington applying for a job, because that's where I expected I would end up. And I got a call from, I think it was either Erwin Griswold, who was later the dean of the law school and was famous, Solicitor General and so forth, or it was Jim Landis, who had been chairman of the SEC and then a leading creator of the statutes that regulated the markets, the Securities Exchange and law and the Securities Act of '33 and so forth. And they called me and said, don't take a job yet. So I said, okay, what do you want? They said, we want you to come back as a member of the faculty and run the Ames competition, which is the through experience that you have learning how to write appellate briefs and make appellate arguments. In those days, there was not a trial. It was an appellate argument learning experience. And you went through a competition. You had a team that prepared the brief and made the oral arguments and worked out the strategy and so forth. And it went through your second year and your third year, and the finals were in the third year. Mm-hmm. They'd always had sort of routine cases that they used that I just suggested to whoever the dean was at the time, was either Jim Landis or Erwin Griswold. I said, why can't we have a current issue of importance? And I think that the one that would be fun would be the issue that's coming before the Supreme Court as to the restrictions that the FCC wants to impose on the number of hours that a network can monopolize. Mm-hmm. And they thought it was a good idea. They didn't really know what I was talking about, but I went ahead and I constructed a record based upon the matters that had been submitted already to the court. So also I said, we've got to have somebody, a really important judge on this case to give it significance and to make it an exciting time for the guys who had to work very hard to wake up and make this up. So somehow or other it ended up with Robert Jackson, who was probably the most, not liberal in the sense of politics, but the guy who had the experience at Nuremberg, and he had later on, of course, but I always knew by reputation, and I think I probably had met him, that he was somebody that was flexible enough that he would work into this pattern. Well, when it came out that these young men in their third year in law school were going to argue this important case, which was scheduled to come before the Supreme Court, the two of the three networks, I think it was NBC and CBS, protested and said they didn't want the case to be argued by these amateurs at the Harvard Law School, who were not really amateurs by that time. And so there was a real argument as to whether we could have the case in the Ames competition. So what happened was either Landis or Griswold decided they would submit it to Felix Frankfurter, who was then a very famous professor and commentator on the law, and he was still on the faculty of Harvard Law School. So they submitted the question to him as to whether it was appropriate ethically and so forth for this case to be heard by the amateur law students before it was heard by the Supreme Court.
Yeah, wow.
Felix said he knew of no law that prevented the judges from learning something about the case before it appeared before him. They went ahead. So it turns out, okay, we're going to go ahead with the FCC issue, and Justice Jackson agreed to come. So I met him at the railroad station, I guess I could. And I had, over the 3 years of the law school before I was on the faculty, I had not spent much time in Boston. There wasn't time for it, with all the work you had to do and so forth. So I picked up Justice Jackson, and we headed for Cambridge. Unfortunately, the wrong way on a one-way street. So he had enough of a sense of humor, so he didn't object for my turning around. So the argument turned out to be fun and very well done. And I think what ultimately happened was the Supreme Court approved the regulation that restricted the networks to prime time, in effect.
Did you get a sense of Jackson at all? I mean, you had a little bit of exposure to him before, but certainly during that time period, as to what kind of guy he was, did you get a...
Well, I got the impression he was practical. He was also intellectual, and had a sense of humor. The kind of a guy that would make a good professor or a good lawyer or a good judge. Right. And I was pleased to have him there, and I had a kind of a limited good time. After all, I was just a recent graduate of the law school myself. So I got that sense that, as I say, we were lucky to have him.
Did you, I know he was a very close friend with Frankfurter. Did you think that Jackson had talked to Frankfurter about the case beforehand, or did he mention any of that?
I don't think so. I think he, although they may have called him and say, Bob, do you have any objections to this? And I think his answer was probably, that's ridiculous.